Good evening, this is Rahul Reddy along with me is REDDY NEUMANN. REDDY NEUMANN PC brings you every week on Tuesday at 5 p.m. Central Time business immigration news. If anybody of you guys have any questions, you can post it on live questions at Facebook and YouTube. We'll try to answer as much as possible. Emily, what do we have today?
So today we want to talk about more of what's going on with these H-4 EADs and the delays that we're seeing, what options we have available, what kind of responses we've been getting when we try to do expedite requests or go through a congressman or senator to get help on that. There are so many different time frames and periods of days that come up in immigration. We talk about a 60-day grace period, we talk about 180-day extension, we talk about the 240-day rule. So we want to break down all of those different rules and which situations involve which time frame, so you can remember all of that. Also, one of the common questions that we're getting right now is for those that filed an H-1B in the CAP this past April and now are looking to change jobs or possibly change a client or project if they're working in a consulting arrangement, and wanting to know if they can do that at this point with their H-1B starting on October 1st. We also want to give you an update on EB-5. New regulations are about to come out that are going to take effect in November, so we'll talk about what changes are in store for that because they're pretty big. And of course, as usual, we'll answer your questions. If we don't get to your question, or if you want more information, want to go into a little bit more detail, you can always join our daily conference call. You can go to rnlawgroup.com to get the schedule for that and the dial-in information. And if you want more detail, you can always set up a consultation with any of our attorneys in our office as well.
Emily, on the H-4 EAD, I just want to explain to people that any of the person who's on H-4 and they suppose I-140 has been approved or they are in the 7th year on H-1B because of the labor certification delay, they are able to file the H-4 EAD. That's the regulation that's been there. Of course, this administration wanted to remove it, but there are some legal challenges that they're facing at this point of time to remove the H-4 EAD. It seems to be that from March of 2019, they began this fingerprinting process. Previous to March 2019, most of the cases used to get approved along with the H-1B. Now, since the fingerprinting process came in, they are not adjudicating the H-4 EADs with H-1B. So now we are seeing a lengthier delays and a lot of people are losing their jobs. Some people are losing the health insurances. They can't get the driving licenses. What options do they have when this administration really want to eliminate the EAD, not by legally, but not following the law? They're intentionally delaying these things.
Yeah, so typically in the case where something is not being processed under normal processing time, usually you would do a service request.
Emily, what is the normal processing time? Is it the website time that they give it, or what is the normal processing time?
Well, back in the day, before March, if it was a premium filed along with a premium processed H-1B, the normal processing time was the 15-day clock of premium. And so when the H-1B got approved, the H-4 got approved, and the EAD got approved. And so when we started seeing delays for these cases, we would contact the premium processing unit and say, hey, what's going on? They're not being approved together. All of a sudden, they start saying, well, H-4s aren't eligible for premium processing, so now you're in the regular processing line. Well, that's never been the case. So once we started getting that response, we started doing service requests under the regular process, but they won't even take your service request because it's still in normal processing time. So no more do we have the 15 days of normal processing time for premium processed I-129s with the I-539. Now we're stuck with regular processing times, which means you can't even do a service request because those are anywhere from 2 months to 18 months, depending on which service center your case is at. So then
which one is 2 months, Emily?
Yeah, so then our next option, you can submit a request for assistance through the USCIS Ombudsman Office. Tried that on several occasions, have yet to get a response on any of them, and now we're almost into August. So then we start doing expedite requests. Under the expedite criteria with USCIS, if you can prove severe financial loss to a company or an individual, then you qualify for an expedite request. Well, they just, within a day, respond to your expedite request just saying, no, we're not going to expedite. Either you don't meet the criteria, which they don't give you any reason why you don't, or they just say, the purpose of an expedite is to get your case moved to an officer. Your case is already with an officer, therefore there's nothing we can do. So then we try congressional assistance, and even they are getting the same response from USCIS that it's within normal processing time, there's nothing you can do. So we've really tried to exhaust every single
doctors
option.
who are on H-4 EAD, they have scheduled surgeries. We couldn't get them done. I don't know what expedited processing the USCIS is going to do. So all options of expedited congressional and service requests have failed. So what other options do you have, and how is this litigation process working?
Yeah, so that's left us really with filing a lawsuit. It's called a delay case under the Administrative Procedures Act. So the Administrative Procedures Act applies to all government agencies and says that each government agency must conclude a matter before it within a reasonable period of time. So we argue that the delay here is not within a reasonable period of time, especially when Congress has given its intention that non-immigrant visa applications should be processed within 30 days.
Yeah.
So once the H-4 and EAD have been pending for 30 days, it's okay to file a lawsuit at that point. That's considered reasonable. Anything beyond that should be considered unreasonable. Now what we do is get multiple plaintiffs that are facing the same situation. We join them all together in one lawsuit and we file. And once we file a complaint against the government, they have 60 days to respond to that complaint. They have to respond to the court. What we're finding is rather than responding to the court, to our complaint, they're just approving the applications. So we've now filed 3 of these lawsuits. Everyone that was included in the first lawsuit received their EAD cards within the 60 days after filing the lawsuit. In our second lawsuit, we've already had several people that got approvals so far, and that was only filed, what, 2 weeks ago?
3 weeks.
3 weeks ago. So we filed another one last week on behalf of even more individuals, and we have the next one that we're planning on filing will be August 2nd. So we are still accepting plaintiffs to join in that one. So you can always give us
There are common questions that come up with this, Emily, is that are you getting the H-4 and EAD approved, or only H-4 approved when you got these approvals?
Yeah, we've been getting the EAD as well. I mean, that's really the ultimate goal is people are losing their jobs.
Yeah, people have this conception that when you go to the court, there is going to be retribution for the USCIS. Mm-hmm. Do you anticipate anything? Have you any experience in that thing?
Yeah, and that would really be illegal for them to do that. For you to use the court to exercise your right is a completely legal step that you have the right to do. And there's nothing that USCIS can do to retaliate against you for exercising your right to get your day in court. So no, we've not seen any kind of retaliation, and we don't expect that to happen.
This is a country ruled by the law, and what our law firm or any other law firm who is going to take you to the litigation against the government is going through the legal sources and the court sources. None of the law officers will take you through the mafia route or any other illegal routes, and I don't think so. So if you're suing the government and you're doing in a legal manner, we should not be expecting any retribution in this country. Anything else that you can give a feedback on the H-4 EAD litigation, Emily?
Yeah, I would say that it doesn't take a lot of work on your part as a plaintiff to be involved in it. If your H-4 and EAD have been pending for 30 days or more, and you have done your biometrics and you're waiting, and whether your current EAD card has already expired or it's about to expire, the best case scenario is your your current EAD is valid for at least the next 60 days, because that will allow us enough time to get the response from the government and get you the approved EAD card
without
losing the job. But many of our plaintiffs have already had their existing EAD expire, and so we're including them in the lawsuit to try to speed up the process of getting that EAD for them. And it seems to be the only thing that's working.
A lot of people ask this question with regards to the litigation, Emily, is that do they have to go to the court or is it only done by the lawyers?
Yeah, that's a great question. So it's, when we file a complaint, it's done electronically. Even us as the lawyers, we don't go to court to file the complaint. It's all done online. So you as a plaintiff do not have to appear in court. The goal here is to file the complaint, and actually, we don't want the government to respond to our complaint. We just want them to approve the EADs and the H-4s, and when they do, we're going to withdraw the complaint. So it should, very likely, the goal is never to get to that 60 days where the government actually has to respond to it.
And the government also doesn't want to respond. There is nothing there that they have legal reasons to delay the H-4 cases. They don't want to respond to that. They practically want these cases to be adjudicated and then call us and tell us to withdraw the application, a complaint, and then which we duly do that and make, it looks like it's a winner for them, winner for us, winner for our clients. Obviously, we don't want the USCIS to delay the cases like the way they're doing, but to satisfy our clients, because the purpose we are filing for litigation is to satisfy our clients. Since the clients got their H-4 and EAD approval, we will end up withdrawing those complaints once we got their H-4 approved. So that's mostly the results it's going to be. Emily, on the 60-day, 90-day, 180-day, 240 days, immigrants go through the journey of F-1 visa, they go through the journey of the H-1, they go through the change of employer, they go through the green card application. What is all this thing? Can you explain, first start with what is the 60-day rule? When is the 60-day rule is applicable?
So there are actually a few different 60-day rules. The first one that you're likely to come across, a lot of our clients come to the U.S. as F-1 students, and that is the 60-day grace period at the end of your F-1 field, program of study. So this is typically where your OPT has ended or your STEM OPT has ended. From that end date, you have 60 days where you are still considered to be maintaining your F-1 status. You can't work during that time, but you can work towards enrolling in a new program of study. You can file a change of status to some other type of visa that you might qualify for, or you can prepare to depart the country. So that's the 60-day grace period at the end of your F-1 stay. Typically happens when your OPT or STEM OPT expires. During the cap gap, it's a little bit different. If your H-1B gets denied during the cap gap, the 60-day grace period is counted from the date of the denial. If your H-1B gets denied after October 1st, then we count the 60-day grace period from October 1st if you're in the cap gap. So those are very important dates to know if you're in that situation where you're transitioning from F1 to H1, especially if you unfortunately get a denial. The other 60-day grace period is for change of employer for H-1 holders. So do you want to give us a little update on that?
If a person is changing from company A to company B, if the I-94 with company A has not expired, the employee may have an unemployment period of up to 60 days. That is allowed with the new regulations that came in January of 2017. So that's when the person is moving from company A to company B, they can have a gap period. Now, please note that 60-day rule here is only applicable if the I-94 with company A has not expired. If the I-94 expires, it does not work. Now, there are some situations where when the person moves from company A to company B, when the company B H-1B gets denied and the company A I-94 valid, it may or may not be withdrawn, valid, under certain limited circumstances, you may be able to use the 60-day to file with the same company B again or with company C again we're using the 60-day rule. We have been successfully used that 60-day rule, but I recommend that if ever you are using that, when you get a H-1B denied with company B, either filing another H-1B application, following the 60-day rule, or filing with company C, I would strongly recommend you consult a lawyer. There are some minus points to those things. You have to consult a lawyer before you do that. So this 60-day rule has to be judicially issued. But if you're moving from company A to company B and you have a 60-day gap, you should be clean. You shouldn't have much problem. Emily, on the 90-day rule, this is called preconceived intent. A lot of people don't know this rule. A lot of people think so that they know the immigration law. It's a little bit tricky thing though. What is a preconceived intent is that when you are entering into United States, if your intention is to come on the purpose for which your visa is allowing, and you change your intention within 90 days. Now we're speaking about 90 days, not 60-day rule. You change your intention within 90 days. The government assumes that you had the intention to change to a different visa status at the time when you entered into United States. It's a presumption that they have, and then you have the burden to prove. So for example, if a visiting visa person is coming into United States, and after entering into United States, let's say the person whom she or he might be already in contact with, they fall in love and they decide to marry, and they marry within, let's say for example, 45 days after they enter into United States. That the USCIS may consider as a preconceived intent, because the person who's visiting United States has changed the intention within 45 days after they enter into United States. Now, if they would have married after 90 days, it may be a different story. So they will look into the 90-day gap period very much. Now, having said that, if somebody has an intention to marry, and they come into United States on a B1 and they get married after 90 days, they will still be in trouble, because if you have the intent of getting married to a US citizen, you're coming on a B2 or B1 visa, you may be violating the terms under which the B1 or B2 has been issued. So you need to be careful when you have intentions that are contradicting your visa. So if you have a visiting visa intention, you want to come into visit Disney or attend any business thing, and you want to move out, that's fine. But if you're coming into United States to get married to a US citizen and file an adjustment of status, B1 or B2 is not an appropriate. Like that, there are different visas, and the rules for those things of preconceived intent is quite different. Any more elaboration on that, Emily?
Yeah, so I think that it's important to know which visas this does apply to. It's typically not really applied to H-1B and L visas.
And H-4s also.
And H-4s and L-2s. Because those allow for dual intent, so you can have the intention of coming in temporarily on that work visa while also be pursuing a green card.
So in other words, an H-1B person entering into United States and immediately getting married to a US citizen and filing an adjustment of status, that's not a problem.
Correct.
But that's a problem for F1 visas because they don't have a dual intent. That's a problem for the B2 visas and B1 visas.
And J1 visas as well.
Most of the non-immigrant visas except the H and L visas. Okay.
All right, now 180-day rule. This comes up in a few different situations. So we'll go back to the F1, where you have finished your OPT and you're eligible for the STEM extension. If you timely file your STEM extension, that's filing the I-765 application, and while it's pending, your initial 12-month OPT expires, your OPT is automatically extended for up to 180 days to allow you to keep working while you're waiting for your STEM extension to be approved. So that's one area where the 180-day rule applies. The other area is for those that have a pending adjustment of status and have an EAD pursuant to that. So what is that 180-day rule?
If the EAD extension has been filed under the adjustment of status, the person can continue working even after the EAD expires. There are two conditions that need to be met. The EAD must have been filed before the previous EAD has expired, and you are limited to 180 days. In both the cases, if there is a denial, the 180-day rule immediately ceases though.
But it's not applicable to H-4
EADs.
or
Unfortunately,
L2
this
EADs.
180-day rule is not applicable to the H-4 EAD. If the EAD expires and you have an extension pending, you cannot continue working on H-4 EAD. Now, the 240-day rule, Emily, on the H-1B extension, can you explain what this is? Is it applicable to extension, transfers, or what is it?
Yeah, it doesn't apply to every type of H-1B. It's only specifically for an H-1B extension for a continuation with the same employer without change. So if you are working for company A and you are working as a software developer and you are going to continue working for company A as a software developer, they're filing an extension without change with the same employer, that is where the 240-day rule applies. So that means that once your extension is filed, assuming it's filed on time before the previous one expires, if then your I-94 expires, you can continue working for that company for up to 240 days while your extension is pending. Once you hit 240 days, your employment authorization ends. You have to stop working. The 240-day rule does not apply to transfers, and it does not apply to amendments. So that's one thing to be aware of, is it's only for extensions without change with the same employer. The 240-day rule applies. Otherwise, for all other types of H-1B amendment, H-1B transfer, you can continue working the entire time it's pending.
Moving on to the next topic, Emily, is the H-4 changing the employers if they are subject to the CAP application and if they have got the H-1B approved or H-1B not approved. I will speak of the situations where the H-1B is not approved and the person is trying to change to a different company. The previous company is forced to withdraw the H-1B. That means that you are not counted towards the H-1B. So I would not recommend that you change the employer before October 1st, and that too, even if the H-1B is not approved, you should not leave. In the situation where you have the H-1B approval, and if you want to change the job before October 1st, that also we strongly recommend you do not change the employer until after October 1st. In situations where you lost the job, and if your employer withdraws the H-1B before October 1st, technically speaking you are not counted towards the H-1B number. So in case situations where the H-1B is approved, if you are forced to leave the job, and if the previous company does not withdraw the H-1B, I would recommend you file the H-1B transfer application on October 1st and not before that. Because by that time you cannot apply for transfer from H1 to H1B because you're already an F1. So that portability of continuous working is not applicable. I would recommend you file on October 1st. Any difference?
Yeah, and same thing for if your project or your work location changes. We would typically recommend waiting until October 1st to file that amendment of the H-1B that's approved. This is a situation where your H-1B is already approved and now you are being moved to a different work location. We would file that amendment on October 1st when the H-1B takes effect. If your work location changes due to a client change or project change and your H-1B is still pending, that may be very difficult to get the H-1B approved. So it's definitely best to avoid that kind of situation. Lastly, before we get to questions, we wanted to talk about the EB-5 new regulation. It's about to be published and it's going to take effect from November 21st. So any EB-5 application filed on or after November 21st is going to be subject to a higher investment amount. It used to be $1 million, it's going up to $1.8 million, and then the regional center or targeted employment was $500,000, now it's $900,000. And this is to keep up with inflation because that $1 million was set all the way back in 1990.
1990s.
And it hasn't changed since then. So in addition, they added a requirement that they're going to adjust for inflation every 5 years now. So this level will only be there for the next 5 years. All right, so I think that's everything.
So for the applications that were being filed before November 21st, you are still under the old rule of $500,000 to $500,000 if it's a targeted employment, and if it's a open thing, then it's $1 million. Arvind has a question from YouTube. Can he work on a freelancer for an online website? Is it legal to do on a student status? If you are getting paid, is this an employer? Is it an independent freelancer? If it's an independent freelancer, Arvind, you are not supposed to be an independent freelancer on a student visa. You can be under the you can go through the OPT process, and he must be an employer. You cannot be having freelancer. The reason why you are being given employment authorization in United States is that you can enhance your education, you can get the training. But if you're a freelancer, you're completely independent. You don't need any training. You don't need any employer to guide you. So in which case you are violating the student visa status.
One of the questions I got on Facebook from Shivam is, can we use litigation for a 221G? That's a great question. So this is where your visa application is stuck at the consulate. It's under administrative processing. So I think that there a little bit more limited options when we're dealing with the Department of State. It's a government agency where that's different from USCIS and Department of Homeland Security. There's limited reviewability of the actions taken by the consulate, and I think also we would need to look at, does the individual employee who's applied for the visa have standing to sue the government, or does it have to be the employer that's bringing that action? I don't think we've looked into it very in-depth yet. We've kind of talked about it with our litigation team a little bit to see if that might be an option. There's, I think, more obstacles to that kind of litigation compared to the H-4 EAD, for example, but we are exploring that option because they are becoming more and more common, and it's taking longer and longer to get through them.
Jay Kumar has this question from YouTube, that his I-140 has been withdrawn after 8 months. It's saying that it's been, on the online, it's saying that it's been denied. Jay, you can do one thing. You can file a freedom of information. You can do it online. It takes only about 30 to 40 days to get a result on it. You will get the copy of the I-140 petition. It will have clearly whether your I-140 was been denied or is it been withdrawn. So once you have that in your hand, you will be more confident. And it's easy, and we recommend people to do by their own self. You practically won't need a lawyer to file this online application form, which is very simple.
Karthi has a question about lost passport and filing an H-4 extension. So in his situation, his wife's passport got lost in the mail, and they're going to apply for the replacement, but that one had her valid H-4 visa stamp in it. He wants to know if she can file an extension of her H-4 without having that passport with the valid visa stamp. And the answer is yes, because the extension, you're going to be filing that based on your I-94, the H-4 I-94 that she received. So the visa stamp that's in the passport is what gets you into the U.S. That's what you show at the port of entry to be granted admission into the U.S. But once you're here, it's your I-94 that shows that you're in valid status and how long you can stay. So you'll use the I-94 to file the extension of the H-4 regardless of the visa stamp being in the lost passport.
Two questions on the H-4 EAD litigation. Sandeep has this question: at what point should you contact the REDDY NEUMANN PC if they want to join the litigation? The one thing I want to tell you is that for the August 2nd litigation, this Friday is the case, August 2nd litigation, the last date for us to take is July 25th that we are going to take the case. Sandeep, there are a couple of things that you need to meet before you need to contact. Your H-1B must have been approved. The H-4 and EAD must have been pending for 30 days before we can file a litigation. Of course, it will take 1 week. You can contact after you are about 22 or 23 days so that we can start preparing the application for litigation. We all know that they are not going to approve in 30 days. That's been going on. But we cannot file the litigation until it's 30 days since the time you file the H-4 EAD. Another question is that Deepthi has it, can we expedite the L2 EAD in the same litigation process? One, Deepthi, is that we are not trying to expedite by filing a litigation. What we're trying to do is that the Congress intended the administration to adjudicate the application in 30 days. All we are requesting is that to comply with the 30 days. Expediting is a different process, but we are not trying to expedite. Now, when it comes to the L2 EAD, it's the same principle for L2 EAD. There's no different principle. We can add you into the litigation and file it, and definitely the judge will look into differently when there are H-4s, L2s. It's not one particular category that these people are delaying. They are just delaying universally for all the people, for all the things. So L2 EAD will add to the beauty to the litigation that we're going to be filing.
Bhavna has a question about her H-4 EAD that recently got extended, but it's for a shorter period than the H-1B spouse's approval is.
That's surprising.
Yeah, so what can be done in this case? So first, I think it depends on the reason for the shortened approval. Was it because the spouse's H-1B approval was not included in the application, or they were filed separately from the spouse's H-1B extension? Or was it truly a mistake by the Immigration Service where you submitted that spouse's H-1B approval notice that's valid to the extended period, but they cut short your EAD? So it depends on the issue. If it's truly a mistake by USCIS, you can contact them to have it corrected. I will warn you, it is a pain to deal with it, and it's not fast. They're so far behind in correcting EADs and sending out lost EADs that were returned that they said it takes 5 months just to do that. You may be better off just filing the extension, but I would definitely contact an attorney to figure out which option is going to be better and more efficient, just based on exactly what happened.
A question came in from YouTube is from Uzma. How can we contact your office to be one of the part of the plaintiff? You can drop an email at info@rnlawgroup.com, and we will respond to you either today or by tomorrow morning. We'll respond to you what the terms and conditions will be. But first thing, make sure that the H-1 must have been approved. H-4 and EAD must have been pending for more than 30 days before you contact us.
Rakesh's employer submitted a premium processing upgrade showing that the application was received by USCIS, but it's not showing anything in the case status. So it kind of depends on the situation. The case status doesn't always update. It's very glitchy, so it could just be one of those glitches. What I would want to find out is, was the filing fee check cashed? Because if it was, then it's been upgraded. You don't have to be worried about that. And also, did the employer or the attorney receive the email notification? So when you upgrade to premium processing or you file in premium processing, there's an email address that you can ask that an email be sent to notifying that it has been upgraded. So I'd like to know if someone actually received that email. If you did, then you don't have to worry about the case status.
A lot of questions are coming in the Senate bill of the per country limit. At this point of time, there is still a hold by Senator Rand Paul. We all want you guys to put a lot of pressure on senators. If you are affected by this bill and you're going to be benefited by this bill, I want you to go to Immigration Girl. There are some drafts that are there for you to write. You can use those things, but don't just copy and paste it. Write, explain it very clearly. Try to contact the senators right now because it's in the court of Senate right now, not in the House. Please explain very detailed your personal situation and write a letter to the senator if necessary. Make an appointment with the senator's office and go meet with them and explain them. Look, this is taking ever for us to get the green card. There are a lot of sufferings that we are going to go through. Now, the talking points when you are telling is that don't tell that this is going to benefit Indians. This bill is not benefiting Indians, guys. All it is doing is that it is putting everybody else in the same line. There is not going to be discrimination. This bill is eliminating the discrimination. So there is a lot of opposition coming out from the other media. They're trying to tell that this is going to benefit Indians, this is going to benefit Chinese. This is not benefiting Indians and Chinese. This is making everybody in equal range. So please, when you talk, don't talk that this is benefiting Indians. This is going to work against you if you do so.
Question for you. If someone has their advanced parole based on a pending 485, and they also have their H-1B that's not stamped, and they need to travel, do you think it's better for them to go for H-1 stamping and come back in H-1, or use the advanced parole?
If you go for H-1 stamping right now, there is about 15 to 20% possibility that they will issue a 221G and will not allow you to come into the country. If you come back in advanced parole, I think so the possibility for them not allowing is less than 0.1%. So you be the judge of that thing. Obviously, when you come back, you're going to lose the H-1B. That's a disadvantage that you're going to have. But if I were you, I would still come back in advanced parole rather than trying my risk on H-1B. I have noticed that people, there are some situations where maintaining the H-1B may be advantage, but in majority of the situations, maintaining a H-1B is actually a disadvantage than an advantage, because if something happens to the H-1B denial, it may affect your adjustment of status.
Resham has a question from Facebook. It's asking, when I'm looking for a new job opportunity to file an H-1 transfer, if it's a significant increase in seniority level, is that something that arouses any suspicion? Is there going to be any problem with filing the transfer or getting the extension? No, should not be any issues with that at all. I mean, as long as you're qualified for that job and the job is still a specialty occupation, USCIS doesn't really care whether it's going up a level in seniority or even a big jump in seniority. So no issues there at all.
Snehal has this question. My I-140 has been approved. Can I file H1, H4, and EAD together in premium processing? Yes, you can. The only disadvantage right now, I hope with all the litigation REDDY NEUMANN PC is doing, they are going to do away with this. But at this point of time, they are not approving H4 and EAD along with the H1B. That's a problem. But yes, we strongly recommend that you file H1, H4, and EAD together. This started when we started getting the fingerprints rule that came out on March 11th, 2019.
So Srikanth asks, kind of along those same lines, is it better to file all three applications together in premium, or should you file in regular processing and then upgrade after the biometrics are done? Which one gets the H4 in premium processing? And the answer is neither of them. They're not approving any H4s or EADs with the premium processed H-1B, regardless of whether you file all together or upgrade later.
Question going on front and back with regards to the Senate bill. Whom do we contact? Congressman, senator? I would say contact everybody. I mean, put a pressure on everybody. Do we have to go only with the co-sponsors, or should I go to the people who even oppose? I would say that first go to the home senator where you are at. Every state has 2 senators. I strongly recommend to write letters to both senators. It doesn't matter, guys, even if the senator is completely opposite to it. If you write a letter, he's not going to be angry. He's not going to take a vengeance on you. I have not known any senator that did that. You're not asking anything wrong thing. You're not asking for any bad thing. All you're asking is to treat you equally along with everybody else. So I don't think so any senator will going to take it. It's better to contact the home senators, make them feel the pressure, make them feel that what you contribute to the society, that you are a law-abiding and tax-paying person in this country. You have a family, you have a home in this country, and you love this country, and you want to abide by the principles of this country. Please tell your senator, try to go with the local senator. It doesn't matter if it's a co-sponsor or if it is an opposing senator. If it is a sponsor, you are actually encouraging him to support the bill more. You're saying thank you to him for supporting the bill. If the person is in the opposition, maybe you can change him. If you cannot change, at least you can change the intensity at which he is fighting against that bill. So I would like you to contact the local senators. Congressman is the next target for you guys. Since it's already passed in the House, it's okay, still contact the congressman, your local congressman, but my personal suggestion is to contact your local 2 senators.
Gautam has a question on an H-1B RFE. It's asking for maintenance of status during OPT time. And in his case, he has his W-2, but can't find his pay stubs from that time. Even though you have the W-2, in my experience, if you're missing pay stubs, USCIS is going to assume the worst and think that you were not working during that time and that you've exceeded the unemployment limit. So one, I would try to go back to that employer and see if they can pull out copies of those pay stubs for you. If not, I'd start looking at my bank statements. If I can show that I deposited the checks, then maybe you can use that as proof of the pay stubs. Maybe your bank can actually print you copies of those deposited checks, but I would definitely try to get more than just the W-2, just because, like I said, the officers tend to assume the worst when you're missing something.
Chetan has this question from YouTube. Is it a good idea to go to the 485 process, or is it better to go to the consular processing because the visa processing time is less? I would not suggest to go to the visa processing. I would suggest you to go through the adjustment of status. Even though there is a delay, you still get an advance parole, you still get an EAD, you don't have a problem with that. So I would not suggest the visa processing in the consulate. I have this question, I'm a little bit emotional on this question, Emily. What is the legal reason behind delaying of the H-4 EAD?
I don't think there is one. I think it's purposely meant to frustrate people who are here legally so they give up and go home. I don't think there's any legal.
My only thing is that this administration is not following the law. When did they ever follow the law? That's the simple question. They are not following the regulations, their own regulations. They are not following the Congress legislation. They're not. I mean, that's the legal reason I can tell you, Snehal. But it's really saddening the way they are doing.
Soma has a good question from Facebook. I-140 is approved. It's been approved for over 180 days and looking to switch to employer B and file the transfer. Once the transfer is complete, I need to file my next extension. Does employer B have to have an approved I-140? The answer is no. So your approved I-140 with employer A, since it's been approved for at least 180 days, can be used to continue to extend with employer B or employer C, employer D. You can keep using that I-140 to keep getting 3-year extensions with any company. Even if employer A has withdrawn that approved I-140, you can still do that until your priority date is current. Once the date is current, then you're only allowed to get a 1-year extension because it's assumed by that point you'll file your 485.
Kritika has this statement, not a question. Justice delayed is justice denied. Emily, I have this question for you. I need your attention. This came from YouTube, from Naveen. He's asking the question, why does the USCIS reject the expert opinion and technical candidate evaluations?
Yeah, that's a great question. They're not supposed to do that unless they have a specific reason for it, or if they have their own expert that they can say otherwise. And so there's some case law out there, I believe it's called Matter of Skirball, that says that if a petitioner is submitting expert testimony, USCIS should accept it unless they have a valid reason for not accepting it. And they're not providing any reason why they're not accepting it. They're not providing any alternate opinion from their own expert. They're just throwing it out. And of course, it's meant to, deny as many H-1Bs as they can.
Pratibhan has this question, and it's probably what we suggested before, but But would you stick on that? Let me see if you're going to stick on that. Is it a good idea to get a H-1B filed under normal processing, get the fingerprints done, and get the premium processing done afterwards?
So
to file the H-4 and EAD together.
Yeah, we've not seen that help get the H-4 or EAD into premium processing, even if you've waited for the biometrics. It doesn't seem to work.
We did suggest that, Pratibhan, at the time before, because we tried all other methods, that didn't work. So we tried this method to see if this works. No, nothing works. This administration doesn't want to follow the law.
Shweta has a really good question from Facebook that doesn't come up a lot, but is very important for people to know. So she got her H-1 approval notice for kind of a shorter period than expected, expiring on July 31st, but the I-94 is valid till August 10th. When I'm filing my extension, do I need to file it before July 31st, or do I have until August 10th to file it, since my I-94 has those extra 10 days? Those extra 10 days are a grace period that are meant for you to wrap up your things and leave the U.S. after your H-1B ends. It cannot be used to file an extension. So you have to file your extension by July 31st in order to be considered to be maintaining your H-1 status. If you file during the grace period, you may end up without an I-94 on your new approval notice, have to go out, get the visa stamped, and come back in order to get back into status. So definitely make sure you're not going by the extra 10 days, go by the actual petition validity period, which is July 31st in your case.
MJ has this question. Can I file the H-4 EAD litigation standalone instead of clubbing up with the other people?
Yes, but it's going to be more expensive. I think
it's going to be more expensive, and the results, you don't expect a miracle result just because you're filing jointly, filing separately. The judge definitely will give more preference when all the applications are put together, because he can act more fast rather than one petition here. It may be very hard for that guy to look into. It's going to be expensive, and I'm not sure you're getting the the results that you want. May not be achievable by that. With the proportion of expenditure and the result proportion, I don't think so. It's a good idea to go standalone.
Navia has a question. She had an H-1B that was rejected last year, so instead was in H-4. And is now studying towards a master's degree while in H-4 status, and wants to know about moving to F-1 now. Is it safe to travel to Mexico or Canada for F-1 stamping? So I'm assuming that your spouse is in H-1 status, not your parent. I think that you're going to have a very difficult time convincing a consular officer, whether it's in Canada, Mexico, or your home country, that you have non-immigrant intent and you intend to return to your home country at the end of your F-1 program when your spouse is in the U.S. in H-1B status. I don't think you'll get the visa stamp in that situation.
Naveen from YouTube has this question. I don't have a EAD. I just have only H-4 application to be filed. And if it's filed with the premium processing, will they adjudicate the H-4 along with the H-1B? Unfortunately, the answer is no. They are not adjudicating the H-4s along with the H-1B, even if it doesn't have an EAD application. This is causing a lot of problems for people. People, who have kids, they are losing their driving licenses. They have a lot of negative consequences when they don't have a driving license. That's a simple thing. There's no legal status. A lot of the places also, they're asking the I-94 validity, and this is not good for people. And they are not adjudicating the H-4s along with the H-1B. We have not seen it from March 11th.
Rikshit has a question. The H-1B extension has already been approved. Of course, the H-4 is still pending, and the I-94 is expiring next month. Can the H-4 continue to stay in the U.S. after the I-94 expired while you're waiting for the extension to be approved? And the answer is yes. As long as the H-4 was timely filed before the current H-4 expires, which it was, the pending extension keeps you in a period of authorized stay, which allows you to legally stay in the country while you're waiting, even after your I-94 expired.
Question came from Sarah that she is an I-140, and she said that losing the H-1B might affect the adjustment of status. She's quoting my words. She wants more explanation on it. That's a good question. Why would losing the H-1B will affect the adjustment of status? One thing, for example, is that if you go for H-1 stamping in India or any other country, you get the H-1 stamping rejected, you cannot come back and advance parole, because once a visa is rejected, all other permits that allow into coming into the United States are invalid. That's one reason. The second reason is that when you are filing an H-1B extension or transfer of application in some cases where you are eligible for the 180-day rule, if your H-1B gets denied, there are reasons why the H-1B is denied, and the AOS adjudicating officer will look into the reasons why your H-1B extension or transfer got denied. Could that has anything to do with your adjustment of status application? For example, let's say for example in the H-1B, specialty occupation is required. Now the USCIS has denied the H-1B extension or denied the H-1B transfer to a different company. Now when it comes to the adjudication of the adjustment of status, the officer is looking, oh, it's not a specialty occupation. This doesn't require a bachelor's degree. Now he has an I-140 that says that it requires a bachelor's degree. So it will be keeping a pressure on the officer not to approve the adjustment of status case. And you may know, Sarah, that the cases that have been filed on or after March of 2017, everything has to go to the adjustment of status interview. So maintaining the H-1B had more disadvantages than advantages.
Mahadev has a question about traveling while an H-1 transfer is pending. He's already joined the new company and has an emergency situation needing to travel. So generally, I don't recommend traveling while you've got something pending. Understand it's an emergency situation. So if your I-94 with company A has not yet expired, you have the valid visa stamp, and you travel while the H-1 transfer is pending, you can return using your valid visa stamp and the I-797 receipt notice for the pending transfer, but you'll only be granted entry up till the date your old employer's I-94 is valid. So that's one thing to be aware of. The other thing to be aware of is while you're outside the U.S., what happens if there's an RFE, or what happens if your transfer gets denied? You won't have a way to come back in until you get that approval, unless you are somehow able to go back to the previous employer. So that is a big risk to take if you're going to travel. I would only do it if it's truly essential for you to travel.
I'm going to go through the questions quickly here, the YouTube questions. Question is that I am getting a promotion. Do I need to file the labor certification I-140? I would recommend that you should contact a lawyer though, because it's not easy depending on, is it a slight improvement? Is it a complete different job description? So the lawyer should be able to evaluate it. It's going to be tough in this YouTube and Facebook Live to comment on that thing. Question from Naveen Chopra is coming is that, will the 1044 affect the advantages that you get with the cross-country chargeability? Yes. Everybody will be in the playing field. Cross-country chargeability at this point of time, you get a lot of advantage. You would lose the advantage of cross-country chargeability if the 1044 goes through.
Anvi has a question. Got the change of status from H-4 to H-1 approved. That's valid through September 2021. But the I-94 still shows H-4 status valid till August 2019. How long does it take for the change of status to kick in? Well, the change of status is not going to take effect until October 1st, assuming that this was a cap subject H-1B. And on top of that, your I-94, I'm assuming you're looking online on the CBP website for the new I-94. The CBP website does not update when you get a change of status. You only get a new I-94 through the CBP website when you travel. Your H-1B approval notice, the I-797 approval notice, has your new I-94 on it in the bottom right-hand corner. That's your new I-94. That reflects your new H-1 status, but again, doesn't kick in until October 1st.
Deepak has this question. His extension is pending for 240-day rule, and he's affected by the 240 days. Can he stay in United States after 240 days? Or does he need to leave the country? You can stay after 240 days, absolutely not a problem, but you cannot continue working. The one reason that I don't understand is that why don't you do premium processing? You have the premium processing. The rest of the H-4 people and all those people who are EADs, I mean, if they would just pay the premium processing, get those things adjudicated, I would tell them to do it rather than the litigation process. In your case, you have the premium processing, you should be using it.
Chetan has a question from Facebook. Is I-485 adjudication faster if you're able to wait outside the U.S. and do it through consular processing? I'm assuming that's what he's meaning. So it's a good question because a lot of people don't understand the difference between adjustment of status and consular processing. So you can only file an adjustment of status if you're in the U.S. currently in a non-immigrant status. You're asking the government to adjust you from a non-immigrant to a permanent resident. So you have to be in the U.S. just to file the 485. If you're outside the U.S., you cannot file a 485. You're instead going to consular process your green card. Now, the two processes are very different. With consular processing, there's no EAD, there's no advanced parole, there's no way to enter the country based on your consular processed green card. And there's a lot more hassle factor to going through the consulate. You have to worry about getting all of your police clearance reports and sending that into the National Visa Center. Affidavits of support have to be done, visa application fee, a lot more has to be done for consular processing, and it does tend to take longer, I think, than filing the 485. But there are some people that don't qualify for the 485, so they have to do consular processing, so that's why it's available.
Viral Kumar has this question. His I-140 has been denied for EB3, and they're filing another application. His I-140 has been denied because he has a 3-year bachelor's degree, and the company is intending to file one more labor and I-140. There are ways to avoid the denial completely when you have a 3-year degree. Emily has written a good article on immigrationgirl.com. You can look into the Indian 3-year degrees. You can look into the article. But to play on a safer side, though, I would try to file an EB3 without requiring any degree, just with experience, if the company is cooperative and the position is available for you, the suitable position is available for you. I would get an EB3 approval without any degree requirement. Then I would take a chance whether I want to go with the EB2 with the EB 3-year degree. We had some successes, we had some very many failures also in the 3-year degree though. A good article is there on immigrationgirl.com. You can look into that. But at this point of time, I want to get my I-140 approval. I don't care EB2, EB3. The best way is to go with the experience requirement and get into the EB3. You retain the priority date, then you take a chance if you want to.
Pooja has a question. I'm on CapGap, and I also applied for my STEM OPT extension, which is in process. If I upgrade my H-1B petition to premium processing and it gets denied, will I be on STEM OPT? So assuming that the STEM extension is still pending at that point, and it's been less than 180 days from when your OPT expired, yes, you will be on STEM OPT in the 180-day period that we talked about earlier that allows you to work for up to 180 days while your STEM extension is pending. The cap gap is no longer applicable once the H-1B is denied.
Does having multiple H-1B transfer raise any questions? A question from YouTube. Absolutely not a problem. You have multiple H-1B transfer, it doesn't raise any eyebrows, it doesn't raise anything. You're perfectly legal. When we oppose multiple filings is when you're trying to circumvent the lottery system, because the lottery system is created to get one chance for you. And even we have seen people who don't even have jobs filing a H-1Bs. That's when we oppose. But if you already have a H-1B, you're going through multiple different transfers and you want to pick which one is, once you get the approval, you want to pick it. Absolutely not a problem.
Vivek has a question on Facebook. To be on the safer side, should we file the H-1B and H-4 and EAD extensions 180 days before expiration? Yes, I mean, that's the earliest you can file. The I-129 is up to 180 days before the start date that you're requesting. So I would try to file as close to that as possible if you need an H-4 and an EAD along with it, so that you have 6 months for the whole process to go through and get the new EAD approved before the old one expires.
Devangi has this question from YouTube. The H-4 and EAD has not been filed along with the H-1B. Can they join the litigation? If the H-1B is approved and even if the H-4 is not filed along with the H-1B premium processing, you can join the litigation. Absolutely not a problem. The next question that comes is, Nitin has this very good question. His employer has withdrew his I-140 application, I-140 approval after it's been pending for more than 180 days. And I'm assuming that the withdrawal occurred after January of 2017. Now the question is that, can he use that I-140 approval to get an H-4 EAD approval? The answer is yes, absolutely not a problem. The requirement has been, I-140 has been approved for more than 180 days, and it's been withdrawn after January of 2017. That I-140 now belongs to you. So you can use it for H-1B extensions, you can use it for H-4 EAD. Good question from Nishant. Last year, my H-1B got denied due to the specialty occupation. Can I sue the government after 1 year? Yes and no. I mean, technically, there is no bar for you to file an complaint to the court if the merits of the case is good. The main question that comes is that when you're going to the court, when you're asking for a relief from the court, what is the relief going to benefit you or not? If you still have the job and this H-1B approval will get you continue to do the job, it is probably worth for you to discuss with a litigation lawyer. And if you were to do it with our office, you can go to rnlawgroup.com. We suggest that you make an appointment with Jonathan Wasden. That's the person we recommend if you really want to litigate that. But you need to have when you're asking relief, I want to get the H-1B approval to work for this company. If you don't have a job there, it's definitely not worth the expenditure that you're going to be conducting. And the judge is not going to give you any relief for you. Anything else, Emily?
One last question from Facebook. What happens to a pending H-4 and H-4 EAD if the H-1B spouse changes employer? So they should continue to be processed. So the H-4 and the EAD are not tied to a specific employer. They're tied to the H-1B spouse's status. So as long as the H-1B spouse is maintaining status, whether that's based on the approved petition or the pending transfer, the H-4 and H-4 EAD should still be processed as normal.
I have seen in cases where when the person has moved from company A to company B, when they approved the H-4, even though the employee did not submit the H-1B approval for the new company, they looked into the company B's approval. They gave the approval until when the company B's H-1B is approved. However, what I would do is that if the H-4 is still pending, if the company B's transfer has been approved, I will do an interfiling and send the H-1B approval with company B to the H-4 application, indicating to the officer, look, I'm not working with company A, I'm working with company B. Here is the H-4 approval, H-1B approval, and they will consider that.
All right, well, if we weren't able to get to your question, we will, you can always join our daily conference call. Again, that you can go to rnlawgroup.com to get that. And I also wanted to mention, we talked about it a long time ago, but we do have a podcast. If you are interested, every day it gets uploaded. So it's on iTunes. You can go to iTunes and look for the Reddy and Neumann podcast there, and you can get even more answers to your questions every day.
Thank you very much.